right, so in this lesson, we're going to start looking at Supreme Court cases dealing with federalism. So we've already talked a little bit about McCulloch v. Maryland, as well as Gibbons v. Ogden. So we're going to look at some other court cases that deal with federalism. The first one is going to be U.S. v. Lopez, and this case is determined in 1995. This is one of the required cases for the AP exam, so make sure that you know the background and some of the details as well as the ruling of this case. So in March of 1992, Alfonso Lopez, who is a high school senior, enters his school in San Antonio, Texas, with an unloaded .38 revolver and 5 cartridges in his pocket. So he plans to deliver this to another student. He's selling this gun and the ammunition for $44, trying to make some money selling the gun. Now, through anonymous sources, school authorities are made aware and they're going to confront Lopez because he brought a gun to school. So he is going to be charged under Texas state law, which prohibited firearms in school. So the first charges he's going to face are under state law. Now, those state charges are going to be dropped. And Lopez is then charged with violating the Federal Gun-Free School Zones Act of 1990. And this act made it illegal for any individual to knowingly possess a firearm in a school zone. So Lopez is going to move to dismiss the charges and claim that the act, so that Gun-Free School Zones Act, is unconstitutional because Congress did not have the power to regulate public schools. So he is arguing that that is not one of Congress's powers. Now the trial court, which is where the case begins, denies Lopez's motion. And they're going to say that the act, so that Gun-Free School Zones Act, was within Congress's enumerated powers because activities within schools are related to interstate commerce. So going back to the Constitution, we know that Congress has the power to regulate commerce. We understand that Commerce Clause. So this court is saying that Congress has that power because activities within schools are related to interstate commerce. Now the case is going to go all the way to the Supreme Court. And the question that the court is going to have to answer is the act forbidding individuals from knowingly carrying a gun in a school zone unconstitutional, so that Gun-Free School Zones Act, is it unconstitutional because it exceeds the power of Congress to legislate under the Commerce Clause? So the question is, does the federal government have the authority to regulate firearms through the Gun-Free School Zones Act within the states under the Commerce Clause? So is this a power of Congress? Now the court is going to rule that the possession of a gun in a local school zone is not an economic activity that might have substantial effect on interstate commerce. Okay? So they are ruling that the Commerce Clause does not allow Congress the power to regulate the carrying of handguns within states. They're going to rule that the law, so that Gun-Free School Zones Act, was a criminal statute that has nothing to do with commerce. Okay, so the Commerce Clause does not grant Congress that power, is what the court is ruling. Now, the court is going to hold that the Gun-Free School Zones Act was unconstitutional because Congress lacked the power to regulate the carrying of handguns within states under the Commerce Clause, okay, because it is that criminal activity and it's not related to commerce or economic activity. So the court is ruling that if bringing a gun to school is considered commerce, then everything could be called commerce and nothing is going to be left to the states. Okay, so remember, initially he's charged under state law. That would have been okay. But because they charged him under federal law, this is how this case snowballs. Now, this case is important because it marks a departure from the court's willingness to accept a very broad range of activities as legitimate subjects of regulation by Congress under that Commerce Clause power. So think back to McCulloch v. Maryland and Gibbons v. Ogden. So Lopez is going to mark the limit of Congress's commerce power. And that is the end of this lesson.